Okay, well, I want to welcome everybody aboard. This is our Caregiving and Capacity Legal Tools for Families webinar. My name is Alan Feller. I'm very happy that you're joining me today on this really beautifully sunny and warm day on May. And I'm just happy to talk with you about this very important topic. And this is something that is so integral, it's such a core element of the type of planning, the type of thinking I want people to do, just to make sure that when things do happen and families are put in these type of positions, that when people get sick and they need help, they need care, that we know what to do. Everything in life is being either prepared or being reactive to the point of being effective. Because when something happens and no one knows what to do and no one knows how to impact things, then that's when real trouble starts. But we'll dig into this, and this is such an important topic. I want people to take careful notes. If you have the workbook, uh, use that wisely. Write down your questions. Write down things that are important, because this is a major topic in what we do. It's basically about helping the people you love and coming up with a plan that makes sense. When we talk about the basics of caregiving, and we always have to start with this lovely disclaimer, which just says the webinar is for educational purposes only. It's not legal advice, and laws vary by state and individual circumstances. Because, as I always repeat, every webinar, if you say, well, Alan said it on the webinar, so I'm relying on it to do my entire planning. No, this is educational purpose. This is something that is for information, and if you put into practice, have a licensed professional follow through with it. One thing I really want to talk about is again why this matters. Why are you on the webinar? Why are you reviewing, all these different pieces of information? This matters because for most of us, and I think a good chunk of the people watching this, myself, people I care about, caregiving responsibilities arises so unexpectedly, so haphazardly that you get pushed into a situation you're not ready. And I'll start with some of my own. My mother, when I was 25, I was just graduated law school. She became very ill, and I was pushed into a caregiving role at 25 years old. And I really didn't relinquish it until she passed away a couple of years ago. So it's not just something that's amorphous or something in the ether. This is something that is directly impacted, and this is something that really hits home. We talk about, why this matters. Caregiving responsibilities will be pushed on you in an unexpected way. A loved one may become seriously ill. There may be an aging bump off where somebody really starts to lose capacity. They start to not to be able to handle things. This is a part of the human experience. Caregiving for me was very personal. My mother needed my help in every possible way. And I'm an elder law attorney, and I was an elder law attorney most of my adult life. So she was getting someone who was already versed in this type of work. So that made things easier on many fronts. But when my father became sick later on in his 60s, it was a sudden illness, fast, and his passing came pretty quickly. But I had done the work previously to be prepared for that. But the caregiving role does get thrust upon you. And what I've learned over the last almost 30 years of being in this world, when you do not have your proper legal plan, then families like mine, like yours, you may face delays in decision making. Financial and medical access may be restricted, and the emotional stress and conflict starts to build and increase. And what was once considered a really close, tight knit family can splinter apart, and those splinters don't get repaired. I mean, you could try, and people make efforts, but these things really do affect the whole family. So if you have proactive legal planning, you get peace of mind. There's no question. So what is the reality of caregiving? By the numbers, we say over 50 million Americans serve as caregivers in one capacity or another. That's a massive amount of people. And we're probably underselling that a little bit. because pretty much everybody at some point will be asked to do something in a caregiving role. But we say 50 million is a reasonable number. And because of that, having some education about it, having some intelligence about it is worthwhile. Take this seriously because this will come about. And yeah, it may not happen now, it may not happen in 10 years, but at some point you'll be dealing with it. And you don't want to just throw your hands up or put your head in the sand and say, oh, I don't want to deal with it, or this is too difficult. This is real stuff. This is like going to school and studying for your exams, taking the SATs, whatever you want to equate it with. This is what you're going to have to do. Be smart, be intelligent, take the time to learn about it. And as I get older and as I do this work longer and longer, I realize everything matters. The mistakes you make, the mistakes you don't make, everything matters. And what happens is when you're a caregiver and you're put in this role, most of us step into it without preparation. It's like, guess what? You're in charge now. What do I do? I don't want that for you. Why I'm doing these webinars month after month is to slowly chip away at some of those insecurities and that lack of confidence, and to say, we can handle this. We can get things done properly. So be prepared, be ready. It's like anything in life, you have a little bit of preparation, it makes sense. And it's easy to say the heck with it, but I don't want that. And then the other pillar of this reality is people's assumptions, because people have come to the office for decades with very specific assumptions. And we want to tell them that legal authority is assumed, but it's not automatic. And we'll give you many examples of it. The most basic that we'll be repeating over and over. Just because you are married doesn't mean you have an automatic legal authority over your spouse. And in fact, just because you're on some joint accounts, you may not be able to access a good chunk of the other spouse's assets, resources, and assorted other information. It's very important to understand. So what happens in real life if you don't plan? We always start off this way, not to scare you. This is not Jaws. This is not Friday the 13th. This is a reality check, just so that when you're watching the video, it's not just passive experience. I don't want you to just watch while you're doing the laundry or while you're getting your pasta ready for dinner. This is not that kind of thing. I want you to really think about this. What happens in real life without a plan? Number one, a spouse cannot access bank accounts to pay bills if they're not attached to it, whether it's a joint account holder, power of attorney, or another very strong link. Being a beneficiary, being a transfer on death, TOD, POD, something else that's not directly linked, they can't access it. Adult children are denied access to medical information if they're not listed as healthcare proxy, HIPAA authorization. These are things, now obviously there are statutes in New York that in the absence of documentation can assist on that. But the problem is then if you want to bring a legal statute into a hospital and say, hey, according to the statute, I should be a person. It's making your life difficult. It creates friction. So let's not do that. Medical decisions are delayed during emergencies. If you don't have your documentation, let's say you don't have a healthcare proxy, you don't have a living will, you don't have HIPAA authorizations, you're missing core documents. And then, of course, you have some difficulty in communicating with hospital staff, with a hospitalist, with a nurse, with social workers. Then to try to get things accomplished without documentation, maybe they can't do that procedure. Maybe a discharge plan can't be put into practice. So these are all things you have to think about. And then, of course, without real planning, without actual documents and thoughtful planning options, families are going to disagree on what the individual would have wanted. Without capacity, that person has lost capacity, the person is not able to make decisions, then how is everyone going to get this done? And then you have very difficult decisions to make, including Article 81 guardianships, expensive, time-consuming. And we'll repeat that over and over because people have to understand the importance of this. So what are some common misconceptions that families have? These are all things we've heard for decades. Number one, as we talked about, my spouse can automatically make decisions. My children can step in if needed. And then we'll figure it out when the time comes. And people have said this. I get this last bubble so often. And again, it's it's part of being a professional that you have to take it in stride. You can't necessarily meet stubbornness with more stubbornness and stridency. You have to be able to deal with it head on, directly, but in a calm, professional manner. Because you understand, yes, they need it, the family needs it, the children need it, everybody needs these things to happen. But you can't force it because people then retract. Now, of course, can children step in if needed? But if they're not listed on documents, if we haven't prepared important documents like advanced directives, then no, they can't just step in. They'd have to file guardianship proceedings. You'd have to go into court and get court orders. So there's no easy way to step in. And as we talked about with spouse, you can't automatically make decisions without a power of attorney or pieces of paper, documentation, putting you on as an authorized party. This is all basic stuff, but I think you just have to get into that mindset. As far as we'll figure it out when the time comes, that just means I don't want to deal with it right now. We'll deal with it later, but later never comes. So why planning ahead matters? Why is this so important? Why do I sit here month after month repeating this? Because it is so important. When you have legal documents prepared, and this is the point at which I want you to take out your workbook, go through it with me, because you're going to write this down and you're going to write your own specific instances and experience in these lines. Again, why is legal planning critical before caregiving needs arise? After what we said, you can answer that question. And again, what challenges do families face without legal authority? You can also put that down too. When you look at questions 3 and 4, you also know the answer. Is there an automated reaction? Is there an automated response? No, you need the legal documents. And of course, what increases, what risks happen when you don't do these things? I think you can write all these down and it'll sink in. It's very important. So to kind of put a timeline on all this and where caregiving can get tricky. I mean, just because somebody gets sick or somebody is dealing with an illness doesn't mean they've lost capacity. It just means they are compromised, maybe physically, and they can still handle things intellectually, mentally, but you're on the clock. When somebody starts to decline, whether it's cognitively, physically, there are things that start to happen where the concern is they may lose capacity, and then without legal documents, we have to then pursue court actions. We don't want to do it. Expensive, time-consuming, stressful, tremendous reporting requirements. Can be a real pain. A lot of people get involved. To avoid that requires legal documentation prepared by an experienced attorney. But understanding capacity is the key and the timeline we have to work with when somebody becomes ill. So what is capacity? Capacity refers to an individual's ability to understand information, make informed decisions, and communicate choices. How a lawyer deals with it is very different than what a doctor deals with, or what a psychologist or psychiatrist deals with. We, as attorneys, look at capacity in terms of, do they have the ability to understand, what their resources are? Do they have a general sense of who the people are in their lives and what basic functions are going to be provided by legal documents? Our standards for document preparation under capacity, the power of attorney, and healthcare proxy is different and comes from different standards than a medical doctor who is reviewing someone's capacity or a psychologist. So this is something I want everybody to focus on, because when we get a report from a family or we get a report from a medical professional saying this person has lost capacity and they can't sign anything, as attorneys, we have to say, we're talking about different standards. If I take this and I present this document in a court of law, a court of law will look at all the elements of a signed document and a person's capacity in a different way than a medical doctor or a medical reporting agency. This is so integral to what we do. So, how do we handle some of the basics of capacity? As an attorney, and for decades I've been doing this, I will engage the person in some conversation. We'll talk about things. We'll talk about the people. We'll talk about documents. We'll talk about the weather. We'll talk about a variety of things to bring their capacity in terms of intellectualization and communication and what their brain is doing at that moment. And you will find out important piece of information. If they're able to engage with politics or engage with sports or engage with the weather and be present and living in the present, living in the actual moment, we can tell that there's a capacity that is worth pursuing. If we don't get these types of conversations, if we can't elicit enough information to present this as someone who has capacity, then as attorneys, we will pull off and not have documents prepared. Very important. So when we talk about capacity on the legal side, it is decision specific, time specific, and not always permanent. A doctor may look at that patient 2 days earlier and say they have no capacity. And we see that same person 2 days later and they're clear headed. They know the people in their lives. They have people that they want to give things to, and they have a decision making capability that is very decent. And I will tell this to medical professionals all the time, and many of them who do this every day do understand the differences, but there are other people involved in medical care, healthcare, hospital facilities that don't quite grasp this, and we have conflict. So important. I can repeat that word over and over again. So important to understand what a doctor says and what a lawyer says about capacity are different. So, and that's the thing. Someone can be really bad one day and really good the other day. Really good is the only thing that matters. So what type of capacity are we talking about? Because we talk about someone's ability to handle resources and money, financial capacity, we also talk about someone's medical decision. Can they have a procedure? What about their discharge? And again, financial capacity goes into power of attorney, because that's the main document that handles financial capabilities. Medical decision making is healthcare proxy, living will, HIPAA forms. In New York State, we have something called a MOLST form, MOLST, which is a ripening form that deals with end of life. But all these parts are, what can they handle while they're functioning, and what they can't handle it, who's going to do it for them? There's also legal capacity, signing a will, signing a trust. There's a difference. If you sign a will, you have to have very specific expectations of capacity in terms of know the objects of your bounty. All these fun legal terms we used to learn in law school, that means that there's a certain grasp of what they have, what they're giving, who the people are. Then there's things like trusts, which have to have the same capacity as signing a deed, which depending could be a little bit different than what a will is. So good to know how all these things work. Now, as a caregiver or as a legal professional, you also should be aware of what are the early warning signs of a diminished capacity. Now, if you are with that person every single day, you may have some jarring bad days, or it could flow seamlessly into incapacity without being aware exactly when that point is. So what are some of the early signs? You start to see some difficulty managing finances. I want you to think about that for a second. Are they having trouble balancing a checkbook? Are they writing checks to people that you have no idea they're writing to? Are they spending out of control? Are they not spending when they need to? Are they not handling things, or bills not getting paid? And again, if you start to see a pattern after many, many years of them being very on the ball and keeping careful records, that's some of your early signs. Big one is confusion with medications or appointments. Just because you have the Sunday through Saturday pill box, and you may see some of those pills being taken, and some days where the pills are still sitting there. So maybe there's some confusion there. Maybe they're taking the wrong medicine on the wrong time. Maybe they're missing appointments. All these different things start to build up and say, wow, my mom or dad is really getting confused. That's a good early sign. Now, are they repeating themselves? Are they repeating questions, forgetting recent events? Do they recall that barbecue from 1975 and what they ate, but they can't remember what you said to them 5 minutes ago? This, of course, yeah, that's aging, and you can call that healthy aging. That's just what happens. But if you start to see this over and over, especially the repetition, if they're asking the same questions and they start to say to your child, "Oh, your who are you?" That's a big sign. And of course, one of the scariest things, again, elder abuse is a major part of the trending in terms of financial protections and what people are dealing with. There's an increased vulnerability to scams. That's why they prey on an elderly population prone to diminished capacity, because they are not thinking clearly. So, of course, if you start to see where somebody calls up and they're about to write a check for $5,000, these are major signs that there's a problem. So, once you start to get a grasp of your loved one's diminishing capacity, what's your window of opportunity? How fast do you have to do things? So, we call this window limited. This is a limited window where an individual still has legal capacity. They have a good sense of still who they are and the people around them and what they own. But there's a slippage. When that limited window presents itself, you can still sign documents, decisions inhibiting them from signing documents. They still have capacity, and that's determined legal setting by an attorney. I mean, that's really what it is. The attorney is making that legal decision. Do they have capacity based on very specific legal criteria in terms of them and their capacity? Once that window closes, and I've been in that position, we talk to someone, we see someone, they are not in a position to make decisions. They're not thinking clearly. There's a real lack of capacity as far as an attorney is considered. The options become limited. So what do we do in that position after that window slams shut? We, at that point, then have to deal with a court proceeding. And in most cases, that's an Article 81 guardianship handled in New York Supreme Court, which we have to deal with for a long time. It's expensive on the legal side and just a difficult proceeding to handle. So again, what causes these capacity changes? Again, you have plenty of medical professionals who will dig into it and be very clearly, we're able to clearly define this. But the truth is, capacity may decline based on cognitive conditions like dementia of the Alzheimer's type, other issues where there's a decrease in blood flow to the brain, and a variety of other things that, as a lawyer, we don't want to delve into because there are medical professionals who can do that better. There's also illness and injuries, pain management, things where they're just not thinking about anything but the pain, how to deal with it. And then, of course, there's medication or mental health factors. People have serious mental illness or have undergone depression or things that are clouding their judgment. And medication, which just changes their thinking. So these are all parts that if they can't get capacity due to these situations, we're talking about an Article 81 guardianship. So this is another time to take your workbook out, look at the understanding capacity, and let's see if you can put down in writing what you believe based on what you've heard and what you've read. What does capacity legally mean? And then can someone have capacity in one area but not another? That's an interesting question because someone may be very vocal and be a good advocate for their own health care and their own care in a facility, but then have a real financial problem with paying bills and handling things. So that capacity could fall into either of those categories. Again, if no legal plan's in place, what happens? You know the answer, but this is a good time to put it down. And of course, what are causes of capacity issues? Same thing. So you've had a good underpinning of what capacity is, what caregiving issues pop up. So what do? You're faced with a situation, your parent or loved one is showing signs of capacity issues, some loss of cognitive abilities, but they haven't lost, beyond the scope of what we can do. So what are our essential legal tools? What can a lawyer do to protect everything? The first document in any list with any conversation in this situation is a power of attorney. Now it feels like as long as I've been doing this kind of law, I've had to sit, prepare, discuss, present, copy, file a power of attorney. Power of attorney is one of those really core things that, and even after all these years, it still is a featured element of the plan. Power of attorney allows a trusted individual, someone you believe in and who you feel has your best interests at heart, to manage finances, pay bills, handle assets and accounts, move money, transfer funds, gift, do all types of things with your assets, with your money to make sure that you are safe, protected, there's no waste, and if you're eligible for Medicaid services or long-term care, that it can be handled efficiently. And that's a power of attorney. And power of attorney form has changed in my career several times. It's gone from a very simple 2 to 3 page form to 5 pages, 8 pages, 9 pages. It just keeps expanding. Then they introduced a statutory gift rider, and then it became just a gift rider. And then basically, this is the situation with how to move money safely, what limits you can do with gifting, and what person and what people, what combinations can be done. So, with power of attorney, this document allows another person to take care of your finances, and you have a choice. You can either make that power of attorney what's called a durable, or as soon as it's executed goes into effect, or you can make it a springing power of attorney. Now, back in the old days, we used to have two forms. We had a springing power of attorney and a durable power of attorney. The springing power of attorney would only go into effect if and when that person had lost medical capacity. And the funny thing is, you would think legal capacity would matter. No, actually, the power of attorney that's springing, they need physician's letter, whether it's one or two physician's letters. Usually two we put in just in case someone has a friend who's a doctor. There are things like that we would put in. We thought about stuff like this, but spring power of attorney, you'll see it both ways. You'll see one doctor, two doctors. The key thing is with a spring power of attorney, it only goes into effect upon a written decision, a written letter by an actual practicing physician that you have lost capacity. Durable power of attorney goes into effect the second it is executed, signed, witnessed, notarized. That's when it goes into effect. And even if you have full capacity, if you give someone a durable power of attorney, they have the ability to handle transactions immediately. That's why we tell people, keep this document in your locked safe deposit box, not in a bank, but your safe in a house or your fireproof box in the house. So this is basically what we talk about. Now, what scope of powers are granted under power of attorney? It'll include gifting, and you can choose to have very little gifts, max gifts, who's going to get the gifts. Your scope of powers also means transfer of funds, paying bills, dealing with real estate, estate planning, or creating trusts, which again is very important if you get sick. You want to see trust creation and beneficiary changing in case someone gets sick. We have to change beneficiaries or create a trust for them. So these are all the scope of powers granted. As far as who can you choose as power of attorney, you could have a single person, multiple people acting separately, or everybody acting together if you're afraid one person's going to run off with the money. Hopefully not. Power of attorney makes sense. I think everyone has a good understanding of how that works now. Hopefully, when you are facing that position, you'll be a little bit better educated. Healthcare proxy, core document, basic document. In fact, most people, when you go into a hospital, you'll be even presented with that form to fill out. That's a form that just needs two witnesses. It's signed by the person creating that proxy. You're choosing one person at a time. You can't have more than one at a time. Unlike a power of attorney, one person makes decisions for you, and then you can have as many backups as you want, but it's only one at a time. And healthcare proxy allows that person you choose to make medical decisions, communicate with your healthcare providers, and then access medical records. We usually like to have a HIPAA authorization attached to it, which gives something very specific, because hospitals and facilities are very used to the HIPAA information. Now, of course, the healthcare proxy really goes into effect if you cannot advocate for yourself, if you have a loss of capacity. If you can still advocate for yourself, make decisions, the healthcare proxy usually should not have that level of control. But that being said, hospitals, hospitalists, facilities, nurses, practitioners, anybody involved with someone's care will often seek some information, guidance, have conversations with a healthcare proxy because they are a person of interest, a person of authority with regards to that patient. So it's never a zero-sum game. There's always some expectation that there'll be coordination. But again, ultimately, it will come down to the person, if they have capacity, the patient, to make decisions. Living will and advance directives, end-of-life care, things like your preferences for how you want to pass on your life-sustaining treatment options. Do you want tube feeding? Do you want different types of hydration, personal health care wishes. Now, this has changed over the decades. It's something that usually we do a living will in the absence of any other people involved with your care. I mean, primarily because someone could choose something with a living will, but hospitals will still talk to the healthcare proxy if you lost capacity and determine, do I make you a no code? You can put in DNR, and this is the reality to keep in mind too. You may say, I want a DNR, I want this is my living will, I don't want this. But if you've lost capacity, but you have a healthcare proxy present and basically involved in your care, physicians, nurses, social workers will be talking to that healthcare proxy to gauge whether or not to follow these wishes, to have an DNR, because they know that with healthcare issues, with medical problems, there's some fluidity. There may be a treatment that's a little bit risky. There may be a sudden drop in someone's overall condition or a sudden jump. So it's never what you think it is when you make these documents. Really, I always tell people, you make these documents just in case no one is available to make the call. You have something in writing that gives them a roadmap. But they will consult with your healthcare proxy. That's a fact. That's how I've been it personally, professionally. I've seen how they do it. For New York, as we talked about briefly, there are things called MOST forms, MOST, where you put specific end-of-life instructions under the basic supervision of a physician. The physician signs off on it, you sign off on it, and that can give you very specific end-of-life instructions, and usually hospitals will follow the MOST form. Keep that in mind. This is the least fun part of the webinar. We talk about what happens if you choose the wrong agent. And usually power of attorney is the big one. I mean, if you have a bad healthcare proxy and they don't handle things correctly, yeah, that's pretty serious too. But we talk about the wrong agent. What happens if you choose a bad power of attorney? Well, financial mismanagement, delayed or poor decision making, lack of communication with family, conflict between family members. I love these little 4 boxes because that's exactly what happens. You put a family together and you build it. Grandparents, parents get together for tons of anniversaries, birthdays, going out to dinner, on vacation, all the cool stuff, all the fun things over many generations and decades. You get a situation where money is involved with people's decline, healthcare crisis, people passing away, and you have something that doesn't go smoothly, a financial mess. That's it. I've seen families just break apart. No one speaks to each other. You can't get people together for a simple birthday, for a simple dinner. And that's the end. And then you think you have a strong family. That family then is nowhere near the strength that it was before. And why? Because maybe your power of attorney, the person you chose to be your point person, your person of significance, and they screw up. They spend money that doesn't belong to them. They take money that doesn't belong to them. They mismanage the funds. They spend it wrongly. They don't communicate with people in the family to create, and this is very important, they don't have a good working relationship. There's decision-making issues or there's procrastination. Yeah, you pick someone in that role who has some real inner strength who can handle this. Now, obviously, not everybody has a family member that they can rely on, and maybe that's the case. And sometimes it works out, sometimes it doesn't, but I'm just telling you what could happen, because ultimately conflict is going to arise when you have the wrong agent under a power of attorney. So when you make this document, we always tell people, who is the one person you trust in your family? It doesn't always have to be an adult child. It could be an uncle, it could be a cousin, that everybody in the family knows has their stuff together, has great head on their shoulders, is not going to play favorites, knows what they're doing, and is above reproach. Choose that person. You may hurt some feelings among your kids, but that person may keep the family together, and everybody will get along and have a good family. You pick the wrong person, all bets are off. So when powers of attorney are not enough, there are situations when power of attorneys do not work in the best way. One of the most troubling parts is when financial institutions reject outdated documents that either weren't drafted correctly, were missing certain parts, missing signatures, missing notaries, didn't have the proper format for that period. Under the law, New York State law is very clear. If a power of attorney is presented to a financial institution, and that power of attorney, even 15, 20, 25 years ago was correct for its time, had the right format for when that statute was in effect, they have to accept it. If they do not accept it because they don't like this or they don't like that, you can do a lawyer letter. We can send it to them, say legally they have to follow this. If they don't follow this rule, we can come after you. But again, pain in the butt, slow, difficult. So this is something we have to deal with from the institution. So if you have an old power of attorney that's not great or has some question mark, it'll be a big problem. We always say, get a good, new, valid power of attorney handled by a professional.